Bryan Kohberger's defense team now demanding the prosecution hand over additional evidence they say may be exculpatory. All this after the accused killer enters a silent not guilty plea in the University of Idaho quadruple murders. Thanks for joining us today for Law&Crime Network. I'm Gillespie. Now, on Monday of this week, a Latah County, Idaho judge entered a not guilty plea on Kohberger's behalf after he and attorney Ann Taylor remained silent. This hearing coming just 1 week after a grand jury indicted Kohberger on 4 counts of first-degree murder, thus avoiding the lengthy preliminary hearing originally scheduled for next month. On November 13th of last year, 4 University of Idaho students were found stabbed to death in their off-campus home. Weeks later, Kohberger was arrested at his parents' home in Pennsylvania and was extradited back to Idaho. At the time of the murders, he was a PhD candidate at Washington State University, and that's just a minute's drive from the University of Idaho campus. So following Monday's court appearance, the case's judge will now hear a defense motion to compel evidence they say the prosecution already has. To explain what this motion means for the prosecution and the defense, Law&Crime legal analyst Julie Rendelman joins us now. Thank you again for joining us, Julie.
Thank you so much for having me, Sierra.
Okay, so let's start with the basics. Just last week, Kohberger's defense team was bombarded with thousands of pieces of evidence they requested from the prosecution. So that included 10,000 pages of reports and other written material, 51 terabytes of audio and video. So Julie, what more could they even be asking for?
So this is the early stages of discovery. And keep in mind that we're dealing with a lot of forensic evidence. Forensic evidence would include potentially DNA evidence, notes from any of the individuals that evaluated any of the evidence, expert witness information. There could be cellular data that is quite voluminous. There could be still interviews of witnesses that are outstanding. Officer reports. Remember, this was a pretty broad investigation, and as a defense attorney, you're going to want every single thing that is in the prosecution's possession for you to determine, not for them to determine, but for you as the defense to determine whether or not anything they have is potentially exculpatory for your client.
So I do want to point out, though, that Kohberger's defense is asking for grand jury material under this protective order. So usually grand jury proceedings are remaining under seal. Is this different because it's his defense attorneys requesting it?
So the initial grand jury presentation is in fact secretive, but that doesn't mean that the testimony that comes out in the grand jury proceeding remains secretive. The defense has a right to review any and all witness statements and potential exhibits that came out in the grand jury. Potentially, first of all, keep in mind that there might be inconsistent statements from what they said there versus what they said in the past. And by the way, what they may say in the future at trial. The one thing usually a judge will hold back is the actual charges on the law, because that's for the judge's purview, not for the defense. But it is certainly not unusual, and it's quite appropriate for the defense to demand and get the grand jury testimony of each and every witness.
Is that something that would be public to all of us, or just simply to the attorneys who are involved in the case until trial?
So my guess is, especially considering what we've already seen in terms of the gag order in this case, that we will not be hearing or seeing any of the evidence that came out in the grand jury until at least trial. Could that change? Yes. But my expectation is that we won't know what was said other than the broad conversations we've been having in terms of what we believe the evidence is going to show.
Now, according to the defense's motion, an expert witness, investigator, and potentially even a consultant of Kohberger's defense team would want to access this information they're requesting, along, of course, with those attorneys. So does that give us any sort of clue of what the information they're hoping to have received?
Sure. Anytime you evaluate grand jury testimony, or by the way, any evidence that you're getting from the prosecution, and specifically in a case like this, when you're dealing with DNA, potentially cell phone records and computer records, you're going to want to have your own experts evaluating that very same evidence to see if they're going to come to a different conclusion than the experts that the prosecution has. So it's not just the defense that wants to evaluate and review this testimony or whatever exhibits that exist. They want their experts to be able to do the same so they can have their best understanding of what the evidence is and make their own determination of what it means.
So after the defense made their motion here, the prosecution has already asked for clarification about what the defense could potentially mean about this exculpatory information. So Julie, what could the defense mean?
So we don't know. And the reason, obviously, anytime you're a defense attorney, you are looking for things to help your case. Now, something that the prosecution may not view as exculpatory or helpful to the defense can be viewed very differently by the defense. And that's why, there's often a disagreement as to whether or not something is exculpatory or not. And so the defense may not have any specific knowledge of exculpatory material. They may, in a sense, be doing what we call a fishing expedition. But if I'm the defense, I'm going to be doing that fishing expedition because I'm going to want to make sure I have anything that leads in a different direction than my client.
Yeah, it makes sense that they would want as much information as they have so the defense could decide we want to use this, we don't want to use this, etc. But this request from the defense comes as they were likely ramping up for that lengthy preliminary hearing that was set for next month, but now that's no longer going to happen. Is that itself a huge blow for the defense?
Anytime you have a preliminary hearing instead of a grand jury presentation, the one thing that the defense has an opportunity to do is hear the evidence and cross-examine the witnesses. It is a huge blow for the defense that they don't have an opportunity to have a preliminary hearing. And why is that? One, in a preliminary hearing, they get to hear the witnesses live instead of just seeing a transcript from the grand jury. Two, they get to cross-examine the witnesses, which can potentially lead to inconsistent statements for trial and give them a good exposure as to what they can expect at the trial. So I think it was disappointing for the defense when they learned that a grand jury was indicted instead of going through a preliminary hearing.
We do now know, though, that there is an October 2nd trial date set. Is that enough time for the prosecution and defense to prepare for this trial?
My guess is that we're not going to see a trial in October, and that the trial is going to be extended out potentially until the following year. Keep in mind, we still don't even know if there is going to be a potential death penalty sentence. And if there is, the defense is really going to have to ramp it up even more in terms of not only defending their client in regards to the actual facts of the case, but any and all mitigation that he could potentially have in his past that would help them if this becomes an actual death penalty case. Also keep in mind that regardless, we may also never see a trial. This could, I'm not saying it will happen, but it is possible that there could be some type of plea, particularly if there's a plea that would avoid the death penalty for this defendant.
Wow. Yeah. Julie, thank you as always, though. You gave some really insightful information about this case.
Thank you so much for having me, as always, Sierra.
And an October 2nd trial date has been set in this case. As we said, prosecutors now have 60 days to file a notice about whether they plan to pursue the death penalty. For Law&Crime Network, I'm Sierra Gillespie.